On August 11, 2017, white supremacists and neo-Nazis descended on Charlottesville, Virginia to protest the removal of a statue of Confederate General Robert E. Lee. The deadly riot captivated the nation, but it wasn't the first time something like this had happened. Decades ago, a group of neo-Nazis fought in court for the right to demonstrate in a village with a large population of Jews, including many Holocaust survivors. And what happened next changed the way the First Amendment to the U.S. Constitution is viewed. Roughly 15 miles north of downtown Chicago, the village of Skokie was established in 1834 by German immigrants. It evolved into a prominent, majority Jewish community. In the 1970s, approximately 70,000 residents, including 40,500 Jews and 7,000 Holocaust survivors, lived there. Meanwhile, 26 miles south of Skokie, in Marquette Park, was a small brick building called Rockwell Hall. Named after infamous neo-Nazi leader George Lincoln Rockwell, it was home to the National Socialist Party of America, also known as the N.S.P.A., a group of people who held beliefs similar to those of Adolf Hitler's Nazi Party, including the physical, social, and mental inferiority of Jewish people, people of color, and people of different sexualities. The N.S.P.A. was well known for their public demonstrations and their radical, anti-Semitic, and racist beliefs. The worlds of Skokie and Rockwell Hall would soon collide after the N.S.P.A. attempted to demonstrate in Skokie to put their beliefs on display. Citing the large population of Jews and Holocaust survivors, Skokie banned them from marching for fear of psychological trauma and physical violence to its citizens. The question of whether the neo-Nazis should be permitted to march would later be settled in court, and in the process, the small Chicago suburb would become home to one of the largest constitutional controversies in American history. The U.S. Supreme Court case of the National Socialist Party of America versus the village of Skokie is a landmark case that challenged the reach of the First Amendment. It reignited a debate over whether or not something should be legally allowed if it's morally wrong, and some parts of the case would serve as precedent for several controversial hate speech cases in the future. N.S.P.A. v. Village of Skokie is interesting, in part, because of the people involved in it and their backgrounds. David Goldberger, who had become lead attorney representing the N.S.P.A., was the legal director of the Illinois branch of the American Civil Liberties Union, also known as the ACLU, an organization that works to uphold, defend, and protect constitutional rights and civil liberties.
The thing that most excited me about the ACLU was that it defended the rights of everyone, no matter who they were. It was something that I really thought was an important thing to be doing, and there was the ACLU doing it, so I grabbed the opportunity to work for it.
Goldberger, who was Jewish, was contacted by Frank Collin, the half-Jewish neo-Nazi leader and founder of the N.S.P.A. Ironically, Collin, a lifelong Chicago resident, is the son of a Holocaust survivor and the grandson of 2 Holocaust victims, although he denies his claim. Collin was formerly a member of the National Socialist White People's Party. He left the group after a disagreement with its leader and then founded the N.S.P.A., which attracted many defectors from his former group. Collin contacted the ACLU and Goldberger to represent the N.S.P.A. because his group's request to march in Skokie had been denied.
I became the lead attorney in the Skokie case because, in short, no one else would do it.
These two people with polar opposite beliefs united over the idea that everyone should be able to demonstrate their beliefs, whatever they may be, as long as it is done peacefully.
I don't really know how Frank Collin felt about me, but he knew that the ACLU could deliver in defense of his rights, and that was what he cared about. He said, look, to myself, this is the essence of what we do. I'm not defending fascism. I'm not defending Nazism. I'm not defending his viewpoint. I'm defending the right of everyone to speak. And if people think that I'm doing the wrong thing, they're mistaken.
On April 28, 1977, the village of Skokie filed for an injunction against the N.S.P.A. to bar them from demonstrating. The N.S.P.A. fought the injunction because they believed it violated their First Amendment rights. The Illinois ACLU represented the N.S.P.A. with David Goldberger serving as lead attorney. N.S.P.A. v. Village of Skokie had a long and complicated path. It started in the Cook County District Court and then was sent to the Illinois Appellate Court, the Illinois Supreme Court, and later the U.S. Supreme Court, which filed its decision on June 14, 1977. The case was next remanded to the Illinois Appellate Court, and then, finally, to the Illinois Supreme Court, where it would be decided. A prominent argument given by Skokie was that the swastika is such a traumatizing symbol for Jewish inhabitants of the village, especially the Holocaust survivors, that its display would be the near equivalent to an attack. If the argument was seen as valid, it could have potentially won the case for Skokie due to laws regarding fighting words, hate speech, and inciting violence. The Illinois Supreme Court ruled that the swastika couldn't be viewed as fighting words, citing the definition of the term from the ruling of Cohen v. California, which states that government intervention should be reserved for the direst and most critical situations, and should generally be avoided. It reiterates that verbal tumult, discord, and offensive utterances do not meet that level of severity. This decision led to the final ruling that public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers. This meant that just because some people view something as offensive, it shouldn't be prohibited from being expressed. And just like that, the neo-Nazis were free to demonstrate, and they did just that.
I felt that the only way to lose this case would be a calamity for the First Amendment. And if it were lost, then we would be reshaping for basic First Amendment doctrines to the detriment of everyone.
However, due to immense public pressure, among other reasons, derived from the case, the N.S.P.A. instead opted to demonstrate in historic Marquette Park, which was home to the infamous Civil Rights March led by Martin Luther King Jr., where he and a group of his supporters were attacked. After the case, Goldberger would go on to participate in 3 more cases before the U.S. Supreme Court. He now serves as Professor Emeritus at The Ohio State University Moritz College of Law. Collin was eventually removed from his position at N.S.P.A. after being convicted of child molestation, and has resurfaced as an author, writing under the pseudonym Frank Joseph. The ruling that the swastika is not considered fighting words would be used as a precedent for several future cases, most notably R.I.V. versus St. Paul, which ruled a bias-motivated crime ordinance unconstitutional. N.S.P.A. v. Skokie paved the way for similar marches, rallies, and protests to take place, such as the recent Unite the Right rally in Charlottesville, which protested the removal of a Confederate statue. A counter-protester, Heather Heyer, was killed during this infamous event. The Reclaim America March, which advocated for a sovereign, white United States, is another example. It took place in Washington, D.C. in February 2020. N.S.P.A. v. Village of Skokie is an example of debate because it sparked a national conversation and sometimes heated argument over whether the N.S.P.A. should be allowed to march. This topic was debated by citizens, lawyers, and lawmakers, but the debate would be settled in court. In conclusion, the court case of National Socialist Party of America versus Village of Skokie was a landmark case that cultivated debate at every level of U.S. society. It set important legal precedent and opened the door for future controversial protests, marches, and rallies. The case was highly controversial because it dealt with sensitive topics such as anti-Semitism, white supremacy, and freedom of speech just 32 years after the end of World War II, in a community filled with the people who were personally involved and still devastated by Adolf Hitler's actions. It highlighted the divide between what is legal and versus what is moral, and the contradictions and complexity in the religious, personal, and legal beliefs of Frank Collin and David Goldberger were the perfect metaphor for the contradictions and complexity of where legality and morality collide.
I never had any doubts about whether representing the National Socialist Party of America was the right thing or not.